Politics of the United States Virgin Islands takes place in a framework of a presidential representative democratic dependency, whereby the governor is the head of the local government, and of a multi-party system. The United States Virgin Islands are an unincorporated and organized territory of the United States, administered by the Office of Insular Affairs of the United States Department of the Interior. Executive power is exercised by the local government of the Virgin Islands. The judiciary is independent of the executive and the legislature. Virgin Islands residents U.S. citizens but cannot vote in United States presidential election and cannot elect voting members of Congress. However, in the U.S. House of Representatives they are represented by a delegate who can vote in congressional committees but not in the House itself. Virgin Islands residents can vote fully in all elections if they become a resident of one of the 50 U.S. states, while residents of one of the 50 states who become residents of the Virgin Islands can no longer vote for president or voting members of Congress. A federal lawsuit since 2011 in the District Court of the Virgin Islands and now before the Washington, D.C. Circuit Court is currently pending to provide Virgin Islanders with the fundamental right to be represented in Congress and vote for U.S. President. The federal case is Civil No. 311 CV 110, Charles v. U.S. Federal Elections Commission. A similar case was filed in the Superior Court of the Virgin Islands against the local Board of Elections. The cases allege it was racial discrimination present in an all-white and segregated Congress of 1917 that was the impetus to deny the right to vote to a majority non-white constituency. The local case is also pending a decision. Law. The Revised Organic Act of the Virgin Islands of 1954 is the current Organic Act defining the government of the United States Virgin Islands, which were acquired by the United States through the Treaty of the Danish West Indies of 1916. It replaced the Organic Act of the Virgin Islands of 1936 and earlier temporary provisions. It was subsequently amended in 1958 to prohibit political or religious tests, but required a loyalty oath as qualification to any office of public trust. The Virgin Islands Elective Governor Act made the governor an elected office, and further amendments in 1984 removed the right to indictment for certain crimes and the jurisdiction of the Admiralty Courts. There have been several attempts at a constitution. The most recent attempt was the Fifth Constitutional Convention of the U.S. Virgin Islands, which passed a proposed constitution in May 2009 but was rejected by Congress in June 2010. Executive branch. The governor and a lieutenant governor are elected on the same ticket by popular vote for 4-year terms. Territorial Cabinet. Legislative branch. The Virgin Islands Territorial Legislature is the 15-member legislature of the Virgin Islands. The body is unicameral and comprises 7 senators from the District of St. Croix, 7 senators from the District of St. Thomas and St. John, and 1 senator at large. They are elected for a 2-year term to the territorial legislature. Political parties and elections. Judicial branch. The U.S. Virgin Islands has a district court, a Supreme Court and a Superior Court. Judges on the district court are appointed by the President for 10-year terms. Judges on the Supreme Court and Superior Court are appointed by the governor and confirmed by the legislative body. Administrative divisions. There are no first-order administrative divisions as defined by the U.S. government, but there are 3 islands at the second order: St. Croix, St. John, and St. Thomas.